Hello, good afternoon, everybody. My name's Lori Baker. I am the Director of Data Protection for the DIFC Authority. And you probably, if you've joined before, have heard me before give these presentations on updating regarding our recently enacted DIFC Data Protection Law of 2020. This session is on accountability, supervision, and enforcement. And I'll explain what those concepts mean if you're new to it. If you already have some understanding, hopefully we'll enhance some of your knowledge and understanding as well. Joining as well for support is Dina Wilkinson from Clyde & Co. They were key and instrumental in drafting the new law and counseling us through the preparation and enactment of it. And they have kindly joined these sessions as well to be able to give you some feedback from their perspective. Mine will be very much geared towards a regulatory perspective, but if you have questions along the way, please do ask them in the chat box. You can also raise your hand. So you can use either function to let us know you have questions. We'll try to get to everything that we can. If you could also please make sure everybody is on mute and that your cameras are off. That would be best for being able to manage the bandwidth of our session. Right, so I'm going to share my screen. I will get this up and running in just a second. And hopefully you can see our presentation. I'll give it just about another 20 seconds to make sure that it shows up for you. Right, so what we'll be talking about today, and this again will hopefully be a familiar format to you. I want to demonstrate in each of these sessions the consistency with the old law, between the old law and the new law, to ensure you that, hopefully it's not a million miles away for anybody who already has some compliance measures in place around the old law from 2007. The new law hopefully will be enhancements of your compliance program and your compliance position, certain tweaks that you'll want to make along the way, I'm sure, but hopefully nothing too burdensome. And if you're brand new to this, this will give you an idea of the things that are expected under the law generally, the kind of key areas that we focus on in the regulator's office, and also give you an idea as we go through the slide deck how to comply with certain provisions of this law. So we wanted to focus today, as I said, on accountability, which you see there at the top is one of the key updates. I've highlighted as well that we're going over the data protection principles that feed into accountability. We're going to talk about notifications a bit. And what's not highlighted here is supervision and enforcement. We'll get to that separately at the end. So to talk about accountability, we're really talking about things that go into accountability, such as transparency, culture, making sure that within your organization you are being able to answer for and understand fully the principles around data protection and personal data, what that concept really is and what it means to the consumers and clients and even your employees and so on whose personal data you handle. So the data protection law is again focused on the processing of personal data through electronic means, through sometimes other means. And personal data can be anything from anybody. It doesn't matter if it's just quote unquote business data, like an email address. Very often email addresses contain personal information. It can be any number of things that when cobbled together create personal data or a profile of somebody so that you know who that person is. So accountability goes towards putting in place the fundamental support mechanisms to allow for transparency, to make sure that the culture of the organization is ready and willing to help any data subjects who have questions about what processing the organization does. And somebody that's actually appointed and accountable where required, and really as best practice to be able to answer any of those questions. So when we share that accountability with respect to being a regulator as well, we want to see the organizations in the DIFC succeed. We want to know that they are on the right track, and that they fully understand the law, so that our job supervising and enforcing is minimized to the extent that we are confident that you understand what it is that is expected as a result of the law and can answer to the data subjects and answer to us. So we'll talk about that. We'll talk about the data protection principles a little bit in terms of how they feed into this. So, for example, what a privacy impact assessment, or a PIA, as you see on this slide, does to help with structure, governance, and risk-based assessments about what it is that you are doing within your organization. A lot of legal structures around data protection and other sort of regulatory compliance issues are now geared towards um, risk-based assessments, risk-based approaches to being able to comply with the laws that they're subject to. It's very, very difficult to achieve 100% compliance for any organization. So you do have to take that risk-based approach and look at what are your highest risks with respect to the type of data in this regard that you're processing, the personal data in particular that you're processing. If you're engaging in types of processing that is particularly high risk, you want to take the appropriate measures, and then triage that medium and low risk. You want to be able to understand the layout and the lay of the land, really, of your personal data processing operations, and understand where your weakest points are so that you can take mitigating actions to reinforce them. Because again, we're always talking about personal data. We're talking about people who own this data before they handed it over to you as a controller or a processor. And that's important to remember. You're one of those people. You're an employee, you're a consumer. You put personal data out there, you want it to be handled appropriately, because if it's not, it can go towards identity fraud, it can go towards hacking and breaking into personal and private information that you just don't want shared or stolen or what have you. So that's why these principles are really, really important. And then notifications, I want to talk a little bit about that right at the outset as well. So we'll get into those slides and we'll talk a bit about what the purpose of notifications is. When you notify, in the DIFC and with any regulator around the world, really, it's not just us. There's a reason for the fee that we charge, and it is nominal in comparison to the grand scheme of things and the work that goes into webinars like this and outreach and communication with our entities in that jurisdiction, wherever it may be that there is a regulator, a data protection regulator who has a register and that you have to notify. It's part of the transparency basis for us as well. And if for nothing else, it can even serve to demonstrate to the public, what it is via our public register, what it is that you're doing in the DIFC with personal data if you have correctly notified. And we'll talk about that a little bit next. But again, side by side, if you look at 2007 law and the 2020 law, we're not talking about a huge upheaval or any really massive new burdensome requirements. These are things that are trending in international data protection law and best practice anyway, and will only facilitate your doing business with the rest of the world. And within the DIFC, it'll make you a responsible, accountable data controller or processor. So moving on, hopefully whoever was having trouble joining the session is being able to join now. Really unfortunate if you're unable to join. I do apologize, but you won't be on this call to hear it anyway. So we'll try to make sure that whoever was unable to join, you can contact us, or we'll just send the recording in any case, so that you can listen again. And if you are in communication with any of the people that are unable to join, you can let them know that as well, that they'll receive a link to the recording. And we'll be running this session again. Right, so talking about accountability. You can find that in Article 14, the concepts around accountability and what we've legislated for under the general requirements section for accountability. Article 14 sets out quite a few of the parameters that we're expecting to be met with respect to accountability. So starting with putting in place a compliance program based on the data that's being processed, based on the scale of processing, the type of processing that you do. If you are processing personal data in any shape or form, you should have some sort of policies in place for how to manage and handle that data. So I stayed over here on the references column what kinds of documents we could be looking for, you should be looking to enact within your own organization to implement this kind of privacy program, or compliance program, I should say. Internal privacy policies, online privacy policies and notifications. So when you go onto a website and you see at the bottom it says privacy policy, that serves as a notification sort of instrument to the rest of the world about what kind of processing you do. And also internal procedures you're going to want to have in place for how to implement your compliance program. And it's there's no magic to it. It's fairly straightforward. You can Google, what a good compliance program looks like and come up with something helpful. Or you can go to, if you have very complex processing, you can go to law firms like Clyde and Co. or consultants like PwC or what have you. Any of the ones that you could think of in the DIOC or in the region. It's a developing area, data protection, and there are a lot of firms around that do have quite well developed privacy and technology teams. So they'll be able to assist you in terms of getting a decent privacy program and compliance program in place. Technical and organizational measures. This is something that you may have heard of before. This is where it comes from. It's in Article 14. These are measures that you put in place to ensure security, that IT is well supported, firewalls and proper access structures and policies and so on. That training is in place. That's part of these measures. That's an organizational measure, that the communications plans are in place, reporting, risk assessments, all of that are encompassed by technical and organizational measures. It's not just having a good firewall or security in place for your IT systems. And again, you can implement these things through an internal privacy policy, online privacy policy, security policies, access control policies, how you give access, incident management, all that sort of stuff, as well as training and communications, and having the appropriate procedures in place to implement that. Privacy by design and default is sort of a concept that means you build privacy in from the outset of any new process or procedure. And you can even go backwards and look at what you already have in place in terms of business unit processes and procedures and double check that privacy is built in from the outset. Even if you're a business development team, especially if you're a business development or marketing team has certain processes in place, you want to be sure that whatever personal data they're collecting through business cards or cold calling or what have you, if they've gotten contact information from a list somewhere, how have they received that information? Did they receive it appropriately? Is it a legitimate transfer of data to them to be able to use? Would the data subject on that list be aware that they are sort of the subject of a list of information being sent around to be contacted and so on. We have some guidance about that as well. And you might already be, if you're, again, a rather complex or multinational data controller or processor, well aware of the sort of marketing rules that are in place. But this is, again, an accountability principle because it requires you to think about the privacy issues well before ever getting into the actual new process or procedure that you want to, or product or what have you, that you want to put in place. default online preferences. So we have a specific statement here where a controller is offering online services through a platform. The default privacy preferences should be set such that no more than minimum personal data to deliver or receive the relevant services is obtained or collected. It takes some technology know-how and understanding and some design, but hopefully, it should be clear enough to your IT team about how to do that. The data subject should really be prompted to actively select his privacy preferences on first use and able to easily change such preferences. So we're talking about things like cookies and tracking capabilities through your website, without going into an entirely separate, very long e-privacy regulation or directive like they have in Europe that goes into quite a lot of detail. This is one aspect of that we've reflected in the law. Written data protection policy, again, if you have an internal privacy policy and an online privacy policy or notification available for data subjects, it achieves or it helps to instruct your staff internally about how to manage personal data, and also notifies the rest of the world, the data subjects potentially that will be hitting your website and handing over data when they register for a free trial of something or they register to get more information. They know what you're going to do with the data when you collect it and how you store it and all of those elements. And if you need a guide, you could really just go to the DOC .ae website. We have obviously an online privacy policy that gives you fairly good structure of how to achieve what an online privacy policy should look like. Codes of conduct and certification schemes, that's NA for now. Somebody needs to help us accredit one, so that there is a way of complying with these. But basically, again, if you can adopt a code of conduct or be part of a certificate or get certified under a certification scheme for your compliance, we'll look into that in the future, implementing one of those if somebody comes forward. I think there have been some questions about that in the last month or so from certain organizations, but we have not worked with them just yet. And then notifications to the Commissioner of Data Protection need to be made and renewed on an annual basis. I'm going to spend a little bit of time on this one because in our portal, basically, there is an option under data protection to notify or to not notify. One carries with it a fee. If you notify, you are charged a fee based on the type of organization you are, and they vary in range. And if you say you're not notifying, there is no fee. Very often, companies that even do process personal data will select that they don't process personal data because they're not interested in the outset at paying the fee, which puts you in breach of the law, quite frankly. So the fee for processing or to notify that you're processing personal data is nominal compared to the type of fine that could be imposed if you actually are processing personal data and you haven't taken that first step of notifying. So if you're a new-ish entity and you went through your onboarding process already recently, but you didn't notify about your personal data protection operations, you probably should go back in if you are processing personal data and notify. If you genuinely are not processing personal data somehow, and it is, I guess, possible, but it's very, very rare to not be processing any personal data unless you have absolutely no employees, no clients, no customers, no suppliers, no contractors, no third parties of any kind. If you can really genuinely say that you're not processing personal data, then notify that way. But otherwise, most organizations should probably be notifying and selecting that option for notifying the commissioner that you do process personal data. So just a bit of information for you about accountability and guidance. So you can review our guidance page on the Commissioner's website if you want to take a look at what is available about general guidance on the law. This is the general guidance piece. The Guide to Data Protection Law number 5 of 2020 provides extensive information about compliance, and we designed it to be a bit of a playbook so that you can get a sense of, what the key components are and of compliance and what actions you should take. So that piece of guidance is quite helpful. And then I also cited here the UK ICO guidance regarding accountability, and a little quote here to help you understand what's important about it. Taking responsibility for what you do with personal data and demonstrating the steps you've taken to protect people's rights not only results in better legal compliance, but it really does offer you a competitive edge. Accountability is real opportunity for you to show and prove that you respect people's privacy. And it gains trust for you as an organization, absolutely, for sure. If you can demonstrate that you have a culture of compliance and accountability, and you're able to meet the provisions and requirements set out in our law and other laws very much like it around the world, like the GDPR, the UK Data Privacy Act, the laws in New Zealand, certain ones in Asia, certainly certain ones in South America as well. So definitely consider accountability and what it's like in your organization, and take those steps to improving that culture if you think that it could stand some tweaking or updating. Right. So controller and processor obligations, we'll get into this a little bit. Key updates here. We've implemented within the rest of the sections after Article 14 certain requirements around building a culture of privacy in your business. These run through basically Articles 15 to 22, and you can, and certain other articles after that actually as well. But these are the key sort of updates and requirements for you to know about as a controller or processor in the DIFC. First of all, what's the difference between a controller and a processor? Right now, it is defined as two separate things in the law. One is a controller is an entity basically that gets to determine what is done with the personal data once it's collected. So you can have controllers, co-controllers, joint controllers, and processors are the entities that are engaged with the controller to conduct processing activities that they're instructed to conduct by the controller. So they don't have control per se of the data in the sense that they get to direct what happens to it. They are directed, as it were. So some would argue, though, that there should be no distinction between the two at all, and that it should just basically be like any party or entity or what have you should take into account all of these accountability requirements. That's sort of something at a future date that we might consider, but for now we still go with the best practice kind of average here of defining controllers and processors, but they do have the same obligations effectively, or many of the same obligations as each other. Records of processing activities need to be maintained. The appointment of a data protection officer and the conduct of an annual assessment where you do have a data protection officer needs to be considered. And again, we went over DPOs in one of these other sessions, but briefly, only two types of entities need to appoint a DPO, a data protection officer. That is, one is DIFC bodies, which are the government-run bodies of the DIFC, so the DFSA, the courts, the DFCA, and so on, and high-risk processing entities. So if you are an entity that's engaging in high-risk processing, then you have to appoint a DPO, I should say. And we have guidance on how to assess whether or not you are engaging in high-risk processing. In any case, we also have implemented in the law data protection impact assessments and requirements and procedures for the cessation of processing. I'll talk about those two a little bit. So when you're at the outset of doing any sort of new data processing or program in your company or business, you should undertake a DPIA, a data protection impact assessment, to ascertain what kind of impact that processing will have on the data subjects who are the subject of the personal data that's been collected. And I want to share with you, oops, I need to get out of that briefly. Going to go back to my screen here and unshare, share something else with you. Give me just a moment, please. Right. So if we go to screen one, let me just share that. And you can see hopefully this on my screen. Right. So this document is a basic data protection impact assessment. It's a template that we may be posting. You basically can find any sort of similar template like this on other regulators or sites, or just generally out on the, again, if you Google it or search for it online, I'm certain you can find something similar. But this is what a DPIA might look like. So describing your processing, looking at the purposes of the processing, the context of the processing, like for what purposes and what scope you're processing it within, the nature of the processing. Then we have the consultation process, which is basically, have you done any sort of consultancy with the relevant stakeholders to seek individuals' views if you need to, if you don't think you need to or don't need to justify what kind of processing you're doing. You may not undertake that, but it is a good question to ask within your organization. Have you asked, or do you need to ask your processors to assist you with gathering this sort of information and feedback from those whose data you would be collecting? What is your lawful basis for processing? So what is it necessary? Is it proportional to process the data? Then you look into things like how do you prevent function creep? What about your data quality and minimization requirements here? I'm going to just take a peek because I'm getting messages through, and I want to be sure that it's not someone telling me that you can't see my screen. Okay, good. So presumably you can see my screen. Okay, right. We want to know things in your data protection impact assessment about how you will support data subjects' rights. And this really, as you can see, all goes towards those fundamental principles of data protection. And then there's a section for identifying and assessing risk and identifying measures to reduce risk. So these are the kinds of things that you'll want to consider when you are doing a data protection impact assessment. And as I said, there are all sorts of similar looking templates out there that you could find. We may put this one on our website at some point as well. We'll notify everybody if we do. And one last tab that you can take a look at here is a checklist for compliance with the data protection law. Something that you can set out to do very easily on your own. This is just organized by, and you'll look here and you'll see very much that it aligns with what is in the PowerPoint slide. So this checklist we'll be talking about a little bit more as well, but it basically gives you, step by step, the articles of the law is probably one way you could approach it, and kind of keep a tally of, are we complying with this or not? Have we done these things that are under this article or not? And it makes it very, very simple to maintain and check your compliance. And you could even add another tab here for your record of processing activities. So your ROPA tab. And your record of processing activities is basically just your list of all the types of processing activities that you do with respect to your DPIA and what you've assessed there. What kind of suppliers you're using, list those suppliers, list the data that they have and what you've shared with them, list the clients that you have, and if you've shared any data with them. Anything that you can do to list your processing activities is what you want to put on this sort of tab. So I'm going to go back into my presentation, and then we get back into some of the other obligations that controllers and processors have. Data processing agreements, that's something that needs to be in place, whether it's an addendum to a general framework contract, or whether it's directly just an agreement that's separate and apart that covers only your personal data processing. You need to, under the law, document and have a written agreement in place for when you use a processor, for example. And those processors need to have flow down agreements to be able to utilize sub-processors. Your contractual obligations should reflect data subjects' rights and any additional controls around international data transfers, such as whether you use the standard contractual clauses that are available on our site or other standard contractual clauses within your organization, like that from Europe, although ours are basically the same as the European ones. We've adapted them for the DIFC, or whether you have an internal policy or system such as binding corporate rules or what have you for your international transfers when you have sort of intra-group agreements, for example. And then the requirements for having a data breach response and notification procedures, you're going to want to not necessarily have the procedures as a legal requirement, but it would be helpful for you to have some sort of incident response and notification procedure in place so that you do respond in a timely manner and notify in a timely manner either us as the regulator or the data subject in the cases where it's required under the law. And we'll walk through that a little bit as well. But most importantly, your obligations should be, even though it's not actually documented in the law, the subtext very much of the law is build a culture of privacy in your business. That's the key, really fundamental thing that you can do. So just again to show you, and as I said, these slides will be available on our website shortly, and you'll get them through email as well if from our comms team. But basically, this shows you what I showed you on that checklist slide. So Article 15 talks about your record of processing activities templates and keeping it up to date, keeping a spreadsheet or other sort of database, whatever you use, is a requirement. Appoint a DPO if you're required to. If you're not required to, you need to still let us know in your notification, who we can reach to talk about data protection. We skipped to Article 20 in this list because basically 17, 18, and 19 kind of go into another direction telling you more about the DPO and their role and tasks. So I don't want to bog you down with that information at the moment. It does say, though, if you do appoint a DPO under Article 20, you should conduct a data protection impact assessment at least annually. This is the annual assessment. And I'm going to jump out again and show you our guidance page. Actually, I need to take you back one page to our forms and fees on the Commissioner's website. And you'll see, right, forms and fees, our annual assessment template that you can use. This is something that we did publish as part of our regulatory requirement to do so. So if you look at this, right, approved template for annual assessment required under Article 19.1 of the Data Protection Law. Right, so this is your annual assessment template. Okay, so you can download that directly from our website. And quite frankly, it is more or less the DPIA template in any case. So you'll see that it looks quite a lot the same. As I said, we may be replacing or adding the other document that I showed you to the website, but this is specifically for the annual assessment, and it's very much similar to the DPIA. Okay, so I'll go back to my slides. And this is the rest of what I mentioned on that first slide at the beginning of this section. Some of the other contractual requirements that you're going to have to meet, having appropriate data processing agreements in place, having transfer mechanisms in place for whether you transfer to an adequate jurisdiction or a non-adequate jurisdiction. And there's guidance on this as well. As I said, in the General Guide to Data Protection, the playbook, it helps you understand what you can and can't do. And then privacy notices, that's your online privacy policy. written policies that cover data subjects' rights, such as the right to access their information or conduct a subject access request. It's really helpful to give your clients an online directive of how you will handle their request. We have that as well. You can look at our guidance page for the DIFC policy on that as a template. And then also Articles 41 and 42 talks about the breach notification procedures. And as I said, this highlights under our comprehensive guidance page what you'd want to look for, the guidance you want to look for specifically with regard to the overall playbook guide. So I'm going to take just a moment. I don't know, Dino, I don't know if there's anything you want to jump in on here before I continue. I won't take questions just yet because I'm mindful of time. I want to keep moving through the sanctions piece and the commissioner's powers. But is there anything you wanted to add, Dino?
Hi, Laurie. No, I think, to add and to reiterate some of the points that you made, what we see as lawyers advising clients both inside and outside the DIFC is definitely that some level of accountability when it comes to data protection does, I think, as you put up the quote from the UK's Information Commissioner, it does create a bit of a competitive edge. It helps to build trust that a lot of consumer businesses do need and do rely on. And so, while it is the accountability requirements have been extended by the new law in the DIFC, the new 2020 law. I think a lot of companies were already looking at that under the old regime. There are similar sort of concepts, the data processing records, the privacy by design concepts in the GDPR and other international laws. But we're also seeing even onshore UAE companies, organizations based in other jurisdictions around the region that don't necessarily have this kind of framework are still looking at some level of accountability or a data protection governance program just to generally manage their risks. So I think it's the law is there, and that those provisions around accountability are to help guide organizations in DIFC to create that culture, but I think many should be well on the way to starting that anyway.
Yep, absolutely, Dino. Thank you for that. I'm just looking at a few questions that I might just quickly answer because I can right now, actually, rather than writing back or saving them till the end. With respect to the annual assessment, if you have to complete one, and let's go to the law, all of it's set out in the law. It's very easy to kind of find and refresh your information, but I'll just point it out. With respect to that, you do have to submit it. If you are required to appoint a DPO, you have to do it in the first place. And then here we go, Article 19. Where a controller is required to appoint a DPO under Article 16.2 or 16.3, the DPO shall undertake an assessment of the controller's processing activities at least once per year, which shall be submitted to the commissioner. So yes, if you are appointing a DPO because you're required to, you also have to do this. Again, and then there are a few questions that I can probably aggregate into ones with similar themes. Do you have to do a DPIA? You should, yes. Basically, it says under the law, prior to undertaking high-risk processing activities, you shall carry out an assessment of the impact. A single assessment may address a set of similar processing operations that present similar risks, etc. The DPO should be responsible for overseeing the data protection impact assessments, etc. We have not published a non-exhaustive list yet of the types or categories of processing operations and what have you. We might do. It's, again, we have published high-risk processing activity guidance, and we have published the annual assessment template, which together really provide that sort of information. We've also provided in our guidance similar information that would give you a good idea of the types of categories of processing that should be considered high risk. So it's all available already, and you don't want to get bogged down with too many documents cross-referencing each other all over the place and not having them up to date and so on. So we're trying to keep it clean and efficient for you as well. But we may consider adding on to this if it's necessary. With some additional information about types and categories, as well as it says here in subsection 4. The law, as well, as I said, does give you quite a good list of what you should look for or what you should contain or have to contain in your data protection impact assessment. So just really go to the law and/or the regulations and the guidance. It's all there for you, any of these questions that are coming in. So in the interest of time, I think I'm going to pick up and move on to the next bit in terms of what the Commissioner's Office does and what his objectives and powers and functions are. So Article 46 of the law sets out the objectives of the Commissioner. Beginning with being able to make regulations, there are duties and functions conferred on him through those regulations and through this law. The regulations are available on the data protection page as well, incidentally, and here in this link. And as I said earlier, these slides will be available on our guidance page shortly, and you'll receive the links, as Miriam stated in the chat as well. And if you get the slides, all of the slides links will be accessible through the PDF as well. So everything's there. You'll be able to access all of this. In any case, in terms of the objectives, the Commissioner shall pursue the following objectives: monitor, ensure, and enforce compliance with the law. So that's where the next bit comes in, supervision and enforcement. And also to promote good practices and observance of the requirements of this law and the regulations by a controller or processor. And to promote greater awareness and public understanding of data protection and the requirements of the law and regulations in the DIFC, which is exactly what we're doing right now. So the powers and functions of the Commissioner of Data Protection in the DIFC are set out in Article 43. They're quite a lot, too many to number here. I can jump out again, though, quickly over to the law and show you Article 43. Oh, sorry, I should have said 46.3. I misspoke. Yes, 46.3. Without limiting the generality, the Commissioner has the following powers, duties, and functions. You can go through this very long list of all the things that the Commissioner is responsible for. And because of this very long list, as well as the objectives that I stated earlier under 46.2, that's effectively where your fee goes to when you register with the Commissioner. There is quite a lot of work that we do. It's not the kind of work that you see necessarily day to day that you might see from business development or some of the things, more interesting kind of out there stuff that you see in the DIFC, like art exhibits and so on and so forth. But we're here doing the regulatory piece in the background and making sure that, as I said earlier, our companies succeed. And if you're complying with our law, what's really nice is knowing that you're probably complying with similar laws around the world, or vice versa. So it's something that we really want to be there for our companies to be able to do with meeting these functions and powers, and providing that service to you effectively. So you can see, again, it's quite a long list, but you can see it right there in the law if you want to as well. You can go back to the law. So I will jump back to my presentation and try to wrap it up so that we can ask some questions. So with respect to supervision and enforcement, one of the powers or functions of the Commissioner is to carry out inspections, for example, supervision. That's what we refer to it as in the DIFC. So basically, and elsewhere as well, obviously. But what we aim to do is meet with at least 2 DIFC entities per month from all types and activities, including even DFSA regulated entities. We review their data protection obligations and support by answering any questions. We ask questions similar to what was on the first tab of that spreadsheet that I showed you, which was here. Let me jump back. No, that's the annual assessment. Sorry. This basic info piece. So we ask these kinds of questions and some additional other ones. And then what we do with respect to our um, supervisory visit is we help to provide recommendations. We tell you what is definitely in breach of the law and how to rectify. We do unfortunately have to, in some occasions, fine certain entities for not getting to rectifying the um, deficiencies or outright breaches of the law. But really, what we're there for is to make sure that we are reinforcing compliance and we're helping you to get not only your DIC compliance in order, but hopefully it will reflect in compliance with other laws that you may be subject to as well. We can't obviously advise on those things, and we can't act as we don't conduct the supervisory visit as a legal advice kind of session. We cannot do that, but we do point out other particular laws you might be subject to that you want to consider as well, so that you can really get your arms around all of your obligations, because there are quite a few these days. And as I said at the outset and throughout these sessions, we're not looking to make it any more difficult with our law. The law has been in place for quite some time, and improving it with this update was really an effort to improve generally your compliance position. And then, oh, sorry, I tapped my tab a little too quickly. Sorry about that. Enforcement comes in when there are clear gaps or breaches of the data protection law. Enforcement effectively is usually resulting in fines. There can be other types of enforcement, such as directions, further investigations, reporting to other regulators where strictly necessary, and in a way that doesn't, impact somebody's else's data protections rights. But we do have to sometimes report to other regulators. And certainly, as I said earlier, imposing fines is set out in Article 62. So we have general fines, which are rather broad in the sense that if it doesn't fall under a basic administrative fine as set out in Article 62, Schedule 2 of the law at the end of the data protection law, which tells you exactly what each administrative fine might incur. We also have the power now to implement a general fine for something that's quite a lot more serious than anything under the administrative fines. And guidance. Actually, let me swap over here so that you can see the whole page, hopefully. Guidance is available on the DIC website under fines and sanctions as well. And that is one of the types of guidance that, or one of the guidance documents that Clyde & Co. kindly prepared for us. So, it's going to be good and thorough. With respect to the data protection section of the portal, I'm including this to wrap up so that you understand what your notification requirements are and how to achieve it. We get a lot of questions about the portal. Basically, just go to the client portal if you're an existing entity, which I assume most of you are, and go to the service requests for data protection, and you'll be able to update any of the sections that are new under your notification. You can change things while you're in there, add jurisdictions that you send data to. You can remove jurisdictions. You can add data protection contacts. You can make sure that whoever is listed there, because there will be a default listing, is correct. You can, do all sorts of things with your data protection notification that already exists and fill in, as I said, the blanks that are part of the new law. And we'll, continue to work with you on understanding how to do that if you do have questions. But this is basically to let you know, just go to the client portal. If you have any issues with the client portal, you can always talk to our registry services team, and they'll help walk you through how to do it as well. They're very, very knowledgeable, and they know exactly what the enhancements are. There's still some bugs and tweaks being worked out. As with anything, we're standing it up as we go, and it's 98% there, but there are certain issues that you may encounter. If you do, let us know and we'll work through them as quickly as we can. Because the overall client portal is now moved to general onboarding, and it's only about 6 months in, so we want to work out any bugs that are affecting your ability to properly notify. As I said, notification, payment, and objection to fines and all other matters should be managed through the client portal as before. That has not changed. And as always, questions for the Commissioner's Office are welcome. If you want to take advantage of the consultation period that is under the earlier sections of the law that we talked about, or you'd like to organize a voluntary supervisory visit, I can come out and do a supervisory visit with you. Please let us know. We're always happy to add you to our list of 2 a month. It can be more than that. There's no limitation necessarily, but that's what we start with. And just basically parting words, and I'll turn over to Dino as well for any parting words before we get to questions. Review your business's data protection status currently and prepare to update your notifications as needed, both within your organization, all of your policies, everything like that. And also make sure that you visit the portal to align with the Data Protection Law 2020. And there's our email address. That's the General Commissioner's email address if you want to use that. And again, that was inaccessible for a little while, so some of you I'm getting back to in a bit of a delay, but so we are getting back to you and working through those slowly but surely. So please, Dino, if you have any parting comments or anything that you want to add, please take the opportunity now.
Okay, sure. Thanks, Laurie. I think that was a very useful session, introducing that sort of whole concept of accountability. I don't have too much to add. I mean, I would say I think the guidance you've prepared, the guidance that's on the website, and the process of notifying, it does go a long way towards helping companies to understand what their obligations are in terms of a compliance program. And equally, I think the law has been written and structured in a way that does try and make those clear. So hopefully the combination of reading the law and the guidance and taking a bit of advice from yourself or from legal advisors where needed will help companies to understand that. It shouldn't be particularly rocket science. If you're going to do things with personal data that are potentially sensitive or high risk, then you need to think about it and just take some steps. I think it's all a fairly sensible, good practice information governance principles that are incorporated in the law. So yeah, and as I say, we're seeing a lot of companies already, sort of modern companies adopting these kind of things. So it should really be an extension of what hopefully you're doing already.
Absolutely, that's correct. Okay, thanks, Dino. I think you can see the chat questions as well, so if there's anything in particular that you want to field, but I wanted to address one or two, again, of the basic ones about the assessments and the templates. It's all available on the data protection website, and you will be receiving these as well through the follow-up communications from our team. And as I said as well, the PDF of these slides will be available on our guidance page shortly, and all of those same links will be in there. Any of the forms and fees that you need to know about, those will be on our guidance website as well, or on the Data Protection Commissioner's website. There is a section called Forms and Fees, and you can see the table there about what the fees are for each type of entity. Yes, the session is being recorded and it will be communicated to you in our post recording comms. You'll also, again, get links and anything else that you need information-wise, either through our website or in the communications afterwards. There was a question about whether a company can be fined under GDPR and DPL. Yes, and other data protection laws as well. Whatever ones you're subject to in whatever jurisdiction, there's not necessarily a limitation on that, and they're not necessarily condensed into one sort of action. Each regulator has the opportunity to fine. Just like if you use, for example, Europe, there is one regulation for all of Europe, but each country's regulator has the power to fine under that regulation, under the GDPR, within their own country, right? So Germany could fine for breaches in their jurisdiction, as well as France, as well as the UK, well, at least until the end of December. And so can we under our law, so can New Zealand, so can any other regulator to under the laws that you're subject to in that jurisdiction as well. So you need to be aware of more than just the GDPR or the UK Data Privacy Act or our law. If you're a multinational, hopefully your legal and compliance team have their arms around all of the jurisdictions that you need to comply with and how to do that. So, any other questions? Yes, so in terms of KYC data, there was a question about what about data we collect to fulfill our KYC requirements for our clients, their passport or world check report, in some cases in their bank statements or source of funds. I don't know exactly what the question is there, but it could potentially be personal data. And you can't necessarily assume that because a bank or Thomson Reuters or somewhere else did their due diligence and are in compliance with how they've collected the data transfers through to how you're processing and storing this data. Each individual entity has responsibility for maintaining that data. I don't know, Dino, would you like to comment on that at all? Or you don't have to if you don't want to, but.
Yeah, no, sure. I think you're right. I think where the data is obtained from providers, then you'll usually find, if you're looking at the small print from the providers, that they say, you're responsible for, maintaining this data and looking after it in accordance with relevant laws. So, yeah, I think certainly that could be considered personal data. It's often, given the types of entity in DIFC, they will often be processing KYC information, and that will create obligations under this data protection law.
Absolutely. Okay. Let's see, any other questions? Oh, there was a question about whether the data protection officer can be outsourced. Yes, the data protection officer can be outsourced. If you look through Articles 16, 17, and 18, it can tell you everything you need to know about the data protection officer and what the requirements are around that. What their role and tasks are, who can fulfill that role. It can be somebody from somewhere else in the organization as well, not necessarily here in the DIFC or the UAE. It can be, for example, if a group data protection officer does all of the data protection work for that company, as long as it's in line with our law, and as I say, go back and check the relevant articles, you definitely can appoint that person as well and put their name in our portal. I had a question here about when is the first notification to the commissioner due. So to put it this way, the way the portal is set up is basically when you're onboarding, it's asking you questions about what you do. But if you're a new company, you're not doing a whole lot just yet. But put it in the context of what you plan to do. If you're a retail entity, for example, and you're going to be processing personal data because you have clients, customers, payment cards, all sorts of things like that. You want to do marketing, you want to communicate with them somehow, or collect business cards for promotions or for reward schemes, that sort of thing, then you need to notify, right? So just using that as an example. The minute you know that you're going to be processing personal data, whether you're a brand new company at the outset or whether you're a company already in the DIFC and you're processing personal data, it's from that moment that you should notify. There is period of about 2 weeks. Basically, we say 14 days from the moment that you are aware that you'll be processing personal data. If you are already processing personal data, but that type of data changes, or you want to update that part of your notification to say, now we think we're processing high risk personal data and we have to appoint an officer, data protection officer, those things are all in the portal as well to update. And you should aim to keep that up to date because, when I do a supervisory visit, I'll be checking that as well, that information. And I'll just reiterate again for retail entities purposes, there are a large number of retail entities that, unless they have absolutely no employees or customers, are for sure processing personal data, and they have not notified. And it may be simply because of lack of awareness, which is why we're trying to do these sessions now and keep you aware. But I suggest that you evaluate whether or not you need to notify. Reach out to a law firm like Dino's or another one in the DIFC. They're all here. There are a number of professionals available to assist you with making that assessment. And one last thing before we go, I know we're a minute overdue, but I do want to show you as well on our guidance page, we've put together a few um, assessment tools that help you understand whether or not the law is applicable to your organization and certain other data protection officers and data export and sharing are the other two tools that we have. So you can conduct a mini survey to basically tell you whether or not the law applies to your organization, whether you need to appoint a data protection officer, and what kind of export and sharing requirements you need to have in place. So again, last word, Dino, anything else that you want to say to wrap up, or shall we? It's about 1:02. I know we're running out of time. We've run out of time, so.
Yeah, no, I've got nothing extra to add, Laurie. Thank you.
Okay, great. Thanks, Dino. Thank you so much again for joining. Really appreciate your being here to support as always. And I do hope this was informational and helpful to you. Again, it will be provided through recording and through our follow-up comms. And we have extra information for you available on our guidance website that you can always access. And forms and fees is where you'll find the annual assessment /DPI information. Thanks, everyone. Have a great afternoon.